If you have an I-130 petition pending or you're planning to sponsor a family member to come to the United States, what I'm about to tell you could completely change your timeline and fundamentally alter your family's future. Starting February 2026, major changes are coming to I-130 processing priorities, and thousands of families could face unexpected delays that might keep them separated for months or even years longer than they originally anticipated. Some categories will see improvements, but others could face devastating setbacks. Do not click away from this video because this information is absolutely critical for anyone navigating the family-based immigration system right now. Whether you filed your petition years ago or you're planning to file next month, these changes will affect you. The decisions you make in the next few weeks could determine whether you're reunited with your loved ones quickly or whether you face years of additional separation. Stay with me, because understanding these priority changes could make all the difference. Welcome back to my channel, your most trusted source for accurate, up-to-date information about United States immigration, visa processes, and pathways to reuniting families across international borders. I'm here to break down the complex world of US immigration law into clear, actionable information that you can use to make the best decisions for your family's future. If this is your first time watching, please subscribe immediately and turn on notifications so you never miss critical updates that could directly impact your immigration journey. Today, we're covering breaking news about I-130 priority changes that will affect countless families starting in just a few weeks. And you need to understand exactly what this means for your specific situation. The I-130 petition, officially called the Petition for Alien Relative, is the absolute foundation of family-based immigration to the United States. This is the crucial form that US citizens and lawful permanent residents file to sponsor their family members for immigration benefits. Whether you're sponsoring a spouse, parent, child, or sibling, the I-130 is where your entire immigration journey begins. Currently, hundreds of thousands of these petitions are filed every single year, and processing times have been a major source of frustration and concern for families desperate to be reunited. Let me give you some essential context about how the current system works before we dive into what's changing right now. USCIS, the United States Citizenship and Immigration Services, processes I-130 petitions based on several factors, including the type of family relationship, the petitioner's immigration status, and which service center is handling the case. Processing times vary dramatically depending on these factors. Some immediate relative petitions filed by US citizens can be processed in as little as 10 to 15 months, while preference category petitions can take much longer. And that's not even counting the additional visa bulletin wait times that come after petition approval. The immigration system divides family-based petitions into two major categories: immediate relatives and family preference categories. Immediate relatives include spouses of US citizens, unmarried children under 21 of US citizens, and parents of US citizens who are at least 21 years old. These categories are considered immediate because there are no annual numerical limits on how many visas can be issued. Once the I-130 is approved and other requirements are met, the visa or adjustment of status can proceed without waiting for a priority date to become current in the visa bulletin. The family preference categories operate very differently. These include F1 for unmarried sons and daughters of US citizens, F2A for spouses and unmarried children under 21 of lawful permanent residents, F2B for unmarried sons and daughters, 21 or older of lawful permanent residents, F3 for married sons and daughters of US citizens, and F4 for siblings of US citizens. These categories have strict annual numerical limits, which means even after your I-130 is approved, you may have to wait years or even decades in some cases for your priority date to become current before you can actually receive your visa or green card. Now, let's talk about what's changing in February 2026 and why this matters so profoundly to your family. According to the latest official announcements from USCIS, the agency is implementing a comprehensive new priority system for processing I-130 petitions. This new system is designed to address the massive backlog that has built up over the years, but the way they're prioritizing cases could have significant impacts on when your petition gets processed. The changes are being implemented to supposedly improve efficiency and reduce overall processing times. But as with any major system change, there will be clear winners and losers. Under the new priority system, starting in February 2026, USCIS will be processing I-130 petitions based on a tiered priority structure. The highest priority, Tier 1, will be given to certain immediate relative categories, specifically spouses of US citizens and parents of US citizens. These petitions will be expedited through a dedicated processing track with an ambitious goal of completing them within 6 to 9 months from the date of filing. This is actually genuinely good news for people in these categories because it represents faster processing than many current timelines. The second tier of priority will include unmarried children under 21 of US citizens and all F2A preference category petitions, which are spouses and children of green card holders. These cases will be processed with moderate priority with estimated processing times of 12 to 18 months. Again, depending on current processing times at specific service centers, this could be an improvement or it could mean slightly longer waits for some applicants. Here's where families need to pay very close attention and where the concerning delays come into play. The third tier, which will be processed with what they're calling standard priority, includes F1, F2B, F3, and F4 preference categories. These are unmarried adult children of US citizens, unmarried adult children of green card holders, married children of US citizens, and siblings of US citizens. Under the new system, these petitions could see processing times extend to 24 to 36 months or even longer. This is significantly longer than some service centers are currently taking to process these petitions. But there's another layer to this situation that makes it even more complex and potentially frustrating. The new system also introduces what they're calling administrative prioritization factors. This means that even within each tier, certain cases may be processed faster than others based on additional criteria. For example, petitions where the beneficiary is already physically in the United States in valid immigration status may receive higher priority than those where the beneficiary is outside the country. Petitions with complete documentation and no requests for evidence may move faster than those that are missing information or require clarification. Additionally, USCIS has indicated that they will prioritize cases where there are compelling humanitarian factors such as serious medical conditions, the safety of minor children, or other urgent circumstances. While this sounds reasonable on the surface, the lack of clear, specific guidelines about what actually qualifies as compelling means that families won't necessarily know where their case falls in the priority system, creating significant uncertainty and anxiety. Real-world impact on families. Let me explain why these changes could be particularly problematic for certain families with concrete examples. Imagine you're a US citizen who filed an I-130 petition for your sibling 2 years ago. Under the current system, your petition might be nearing approval. But if your case hasn't been decided by February 2026, it could be moved to the lowest priority tier, potentially adding years to your total processing time. Your sibling who has been patiently waiting could face an indefinite extension of time before even getting the I-130 approval, after which they still have to wait for their priority date in the visa bulletin. Or consider a green card holder who filed for their adult unmarried son or daughter. These F2B cases already face long visa bulletin wait times, sometimes over 5 to 7 years, depending on the country of origin. If the I-130 approval itself now takes 3 years instead of the current 12 to 18 months at some service centers, you're adding multiple years to an already lengthy process. For families from countries with high demand, like Mexico, Philippines, India, or China, this could mean waiting 15 years or more in total before their family member can join them in the United States. There's also serious concern about how these changes will affect families who are already in the middle of their immigration journey. USCIS has stated that petitions filed before February 2026 will be transitioned into the new priority system based on their relationship category, not based on when they were originally filed. This means that being in line first doesn't necessarily mean you'll be processed first anymore. A petition filed in 2024 for a sibling could be processed after a petition filed in 2027 for a spouse, completely upending the traditional first-in, first-out approach that many people have come to expect and rely on. Another significant concern is the impact on derivative beneficiaries. When you file an I-130 for your spouse, their children under 21 can often be included as derivative beneficiaries. If processing delays cause a child to age out, turning 21 before the petition is approved, they may lose their derivative status and require a separate petition, creating additional delays and complications. The Child Status Protection Act provides some relief in certain circumstances, but aging out remains a critical issue for many families. Now, let's talk about what you can do to protect your family and navigate these changes successfully. First and foremost, if you haven't filed your I-130 yet and you're eligible to do so, seriously consider filing as soon as possible. Petitions submitted before February 2026 will be grandfathered into the system, and while they'll be assigned to priority tiers, getting your petition on file earlier rather than later is absolutely crucial. Every month you wait is potentially another month added to your processing time under the new system. Second, make absolutely certain your petition is complete and accurate when you file it. Under the new priority system, incomplete petitions or those that generate requests for evidence will likely be deprioritized. This means working with an experienced immigration attorney or being extremely thorough in preparing your petition yourself. Include all required documentation, provide clear and consistent information, and make sure your evidence of relationship is strong and well organized. Third, if your petition is already pending, monitor it closely. You can check processing times on the USCIS website, and you can also create an online account to track your case status. If your case is taking longer than the posted processing times, you may be able to file an inquiry or even consider a mandamus lawsuit in extreme cases, though you should consult with an attorney before taking such steps. Fourth, stay informed about visa bulletin movements if you're in a preference category. Even if your I-130 is approved quickly, you'll still need to wait for your priority date to become current. The visa bulletin is published monthly by the Department of State and shows which priority dates are currently being processed. Understanding how to read the visa bulletin and what it means for your case is essential. Fifth, consider whether you have any other immigration options. For example, if you're waiting for an F2B petition as the child of a green card holder, but your parent naturalizes and becomes a US citizen, your category could change to F1, which typically has shorter wait times. Or if you're eligible for employment-based immigration, that might provide an alternative or faster path. Every family situation is unique, so exploring all options with an immigration professional is worthwhile. It's also important to understand the political and practical context of these changes. USCIS has been under enormous pressure to reduce backlogs and improve processing times. The agency has faced criticism from Congress, immigrant advocacy groups, and the public for lengthy delays that keep families separated for years. These priority changes are meant to address those concerns by focusing resources on the cases that should theoretically move fastest. However, critics of the new system argue that it creates a two-tiered immigration system where some families are valued more than others. They point out that sibling and adult children are still close family members who deserve to be reunited with their US citizen or permanent resident relatives. By deprioritizing these categories, the government is essentially saying that these relationships matter less, which many find troubling from a family values perspective. For families who are facing these potential delays, the emotional and practical impacts can be absolutely devastating. We're talking about spouses separated from each other, children growing up without a parent, elderly parents unable to be with their adult children in their final years, and siblings who may never have the chance to live near each other. These aren't just bureaucratic delays on paper. They're real consequences that affect real people's lives in profound and heartbreaking ways. If you're feeling overwhelmed by all of this information, that's completely understandable. The US immigration system is incredibly complex, and changes like these add another significant layer of complication. I want to emphasize that while this news about priority changes is concerning, it's not a reason to give up hope. thousands of families successfully navigate the immigration system every year, even with its challenges. The key is staying informed, being proactive, preparing your case thoroughly, and seeking help when you need it. Thank you so much for watching today. I hope this breakdown of the I-130 priority changes has given you a clear understanding of what's happening, why it matters, and what you can do about it. If you found this information valuable, please give this video a thumbs up and share it with other families who are going through the immigration process. Knowledge is power, and the more informed our community is, the better equipped we all are to face these challenges together. Make sure you're subscribed to this channel so you don't miss future updates about immigration policy changes, processing times, and strategies for reuniting your family. Drop a comment below if you have questions or if you want me to cover specific topics in future videos. Remember, your dreams of family reunification are valid and worth fighting for, and I'm here to provide you with the information you need to make those dreams a reality. I'll see you in the next video. Stay strong and stay informed.